Welcome to my episode Tax Decoder. Myself Anil Diwan, the founder of Tax Chanakya. Friends, Section 138 of the Income Tax Act 1961 is a very important section. It provides the privacy of the information you provide to the Income Tax Department. It deals with the disclosure of information relating to the taxpayers. As a general rule, all the details furnished by the SSC in written statements or document submitted to Income Tax Department are treated as confidential. However, the law empowers the designated income tax authorities to share such information with other government departments, courts, or law enforcement agencies when it is considered necessary in public interest or legal proceedings. So informations are not available through the right to information. RTI के अंदर information available नहीं होगी. The central government is also authorized to frame rules specifying the nature of the information that can be disclosed and the authorities to whom it can be provided. Thus, Section 138 strikes a balance between the maintaining the confidentiality of taxpayer information and allowing its disclosure where required for governance, investigation, or enforcement of law. The Delhi High Court on RTI versus Income Tax Act in PM care cases is a very important judgment. We are going to discuss this judgment. It's a Delhi High Court order or judgment. Tax headquarter exemption versus Girish Mittal decided by the Delhi High Court on 22nd January 2024. This is a very important judgment by Delhi High Court. This case sits right at the intersections of the Right to Information Act 2005 and the Income Tax Act 1961, and it asks a crucial question: can citizens use right to information to access the income tax exemption record of PM care funds, or must they follow the Income Tax Act procedure instead? Now, Girish Mittal filed an RTI application asking for the copies of documents related to the approval of income tax exemption under Section 80G of the PM Care Funds. Now, Central Government Commission in April 2022 directed the Income Tax Department Central Public Information Officer to provide this document, but the Income Tax Department pushed back. They argued that such information falls under the Income Tax Act disclosure provisions, specifically Section 138, and therefore cannot be directly assessed via RTI. So information is not available through the right to information. So the department challenged the Central Information Commission order before the Delhi High Court. The department's counsel, Mr. Sohaib Hossain, raised three main important points. The first point was Section 138 of the Income Tax Act lays down the exclusive procedure for disclosure of any SSC related information. Citizen must apply to the Chief Commissioner, and the disclosure happens only if that authority is satisfied that it is in the public interest. Now, second point, the RTI Act Section 8 subsection 1 clause I exempt personal information from the disclosure. The third point is that since the case involved the PM Care Fund, a third party entity, disclosure could not happen without giving PM Care Fund a chance to be heard under Section 11 of the RTI Act. Now, on the other hand, the respondent argued strongly in the name of public interest. His counsel said the 4 points. His counsel again given the 4 points why they want the information. First, the PM Care Funds is a public charitable fund created for the COVID relief. It was created at the time of the COVID. Now, citizens have the right to know how quickly the Income Tax Department granted it exemption under Section 80G. Was due process followed? It's an investigation of the entire process which was been followed. Now, third point, he also evoked Section 22 of the RTI Act, which says RTI overrides all other law, including the Official Secrets Act. He cited the Supreme Court judgment in ICSI versus Paras Jain 2019, which allowed the applicant to use the RTI even when another route was available. In simple terms, the respondent argued if two laws give two paths to the same information, the citizen should be free to choose the RTI. Now comes the heart of the judgment by the Justice Subramaniam Prasad. The court carefully compared both the laws. Income Tax Act is a special law. It specifically deals with the disclosure of taxpayer-related information. Now, RTI is a general law. It broadly gives the citizen access to information. Third, When there is a conflict, the principle of generally speciculus non-derogant applies. Special law prevails over the general law. Now, fourth point, Section 138, subsection 1, clause B of the Income Tax Act requires the commissioner's satisfaction before releasing any associated information. That safeguard cannot be bypassed by the RTI. The fifth point, the CIC also violated the Section 11 of the RTI Act because PM Care as a third party was not given any chance to present its case before disclosure. The court also distinguished the ICSI versus Paras Jain judgment. In that case, there was no conflict between the RTI and any other special law. It was merely about fees. Here, there was a direct clash between the RTI and the Income Tax Act provisions. Finally, the Delhi High Court allowed the writ petition of the Income Tax Department. It set aside the CIC order dated 27th April 2022. The Delhi High Court held that Section 130 of the Income Tax Act overrides the Section 22 of the RTI Act in matters of taxpayer information. Honorable Court declared that CIC has no jurisdiction to direct the disclosures of such information and finally ruled that the failure to give PM Care Fund a hearing as a third party made the CIC order invalid. So when it comes to the assessment-related tax information, including exemptions like those granted to PM Care funds, citizens cannot simply use the RTI. They must follow the procedure under Section 130 of the Income Tax Act, which requires public interest satisfaction by senior tax authorities. In short, special law builds the general law. Income tax is a special law. Now that wraps up today's episode on the Delhi High Court ruling in Central Public Information Officer versus Girish Mittal. It's a fascinating judgment because it shows how the courts balance the right to information with the confidentiality of the tax proceedings. Stay tuned for such deep dive into landmark cases. Myself Anil Diwan from Tax Chanakya. Thank you.